Thank you, Mr. Speaker. Always a pleasure to rise on behalf of the great citizens of Brantford, Brant South, Six Nations. It's more particularly poignant for me, given today's topic and given my prior history in the criminal justice system. And I would dare say, Mr. Speaker, that one of the driving forces for me to leave behind, at that point, almost 28 years in the criminal justice system, to become a legislator is because I saw firsthand, daily, the firsthand tragic consequences of the failed soft-on-crime agenda by this Liberal government. Starting in 2015, making the changes in 2019 with Bill C-75, later in 2023 with C-5 and C-83, the cumulative effect is now Canadians are living in a state of fear. Canadians are waking up every single day to reading, seeing, and hearing about one heartbreak story after another, usually someone who has been killed, someone who has been wounded, maimed, injured, had their car stolen, had their home invaded, been subject to sexual assaults, and lo and surprise, we have individuals who are committing these offenses, who are on numerous releases, who are classified by the police services as being well known to them because they are repeat violent offenders. That is the reality that Canada is facing. This was not the reality prior to 2019, Mr. Speaker. In 2019, there was a balance in our criminal justice system where the rights, the constitutional rights of the accused, the right to be presumed innocent, the right to reasonable bail, was balanced evenly with community safety and the safety of victims. We saw more releases and we saw more detention orders, and people had a level of confidence that things were working as they were supposed to. But this government decided in 2019 to lie to Canadians. Justin Trudeau and his former ministers deliberately lying to Canadians by saying,
Order. There are certain words that we do consider unparliamentary, so I would just encourage the member to leave out those words and carry on with his comment.
Misleading Canadians into believing they were simply codifying language from the Supreme Court of Canada. The decision they were referring to, Mr. Speaker, was Antic. And Antic basically reiterated the principles under the Charter of Rights and Freedoms that apply to people who are factually innocent, although charged with a serious crime. Justin Trudeau and his ministers said they were taking the language from Antic and applying that to the criminal code. Well, the decision in Antic never directed the federal government to do anything. It was a reminder about the balance that needed to take place every single day in every single courthouse in this country. Justin Trudeau and his then Justice Minister, David Lametti, decided to make it one step easier for criminals. They introduced the principle of restraint under Section 493.1 of the Criminal Code, which then said, regardless of the grounds of detention in the Criminal Code, the primary ground, are you going to show up for court? The secondary ground, is there a protection issue for the public? Is there a presumption that this person is going to be incurring further charges if released? And the tertiary grounds, to maintain the confidence of the public, depending on the severity of the charge. Those three grounds worked, but Justin Trudeau and David Lametti decided to introduce the principle of restraint. That telegraphed to every judge and every justice of the peace hearing bail applications to this day that they shall, mandatory language, shall release the accused at the earliest opportunity on the least restrictive conditions. Regardless of what the charge was, regardless of the carnage the charge has caused to the community or to the victim, regardless of the offender's criminal record, which may have showed a pattern of breaching court orders or a pattern of committing that same offense again. And then, get this, Mr. Speaker, regardless of the number of outstanding releases that person may be on, that person, according to this Liberal government, was worthy of release. That, Mr. Speaker, is the origin of catch and release. That is the reason we have the problems that exist today. Now, I know the member for Winnipeg North likes to turn everything into a partisan issue. But to my colleague from Woodstock, this particular bill and our arguments are not partisan, because community safety is not a partisan issue. Every member in this House represents constituents, and those constituents want to wake up in their home that is still safe, the windows are still intact, the doors haven't been broken in, that their vehicle is still in the driveway, that their kids can play safely in the backyard, can play street hockey on the streets, and not be hit by stray bullets, or not be invaded at night, as we are seeing constantly, day after day after day. That's what Canadians want. And that's why this is not a partisan issue. The number one responsibility of that Liberal government, Mr. Speaker, is to keep Canadians safe. So despite what the member for Winnipeg North saying, that the Prime Minister has got a robust agenda that he's promised Canadians, this is a classic bait and switch. We heard these promises during the election. We heard the promises in the throne speech. We have heard numerous members on that side of the House make promises that it's coming. But here we are, 7 months removed from when this Prime Minister became the new Prime Minister of this country, and we are still waiting. And in that time frame, people are dying, people are fearful, people are being sexually assaulted, people are being extorted at an alarming rate. Just take a look at these statistics, Mr. Speaker. Because of Liberal bail laws, violent crime up 55% since 2015. Firearm crime up 130% because of Liberal bail laws. Because of Liberal bail laws, extortion skyrocketed 330%. Because of Liberal bail laws, sex assaults up 76%. Because of Liberal bail laws, homicides up 29%. So that's why, if they don't want to exercise their number one responsibility, get out of the way. Let us bring forth common sense solutions to protect Canadians. I brought a petition that I was hoping was going to go viral across this country this past July, calling for the immediate repeal of the principle of restraint, restoring safe streets, and applying the principle of community safety, just like the member of Woodstock has done in our Jail Not Bail Act. And you know what, Mr. Speaker? Since the middle of July, 60,000 proud Canadians that those members in the government represent, signed my petition. Because for the last 4 years, this government has heard from premiers, has heard from mayors, has heard from presidents of police associations, has heard from police chiefs, has heard from victim advocacy groups to do one thing: change your approach to bail. Keep Canadians safe. So here's your opportunity to the Liberal government. If you want to clearly distinguish yourself and remove yourself from the Trudeau legacy, here is your opportunity. Stand in support of the Jail Not Bail Act or abstain from the vote. But please telegraph to your constituents, who I'm sure are going to be watching our speeches today, and if they're not, I will certainly share it amongst all my followers across this country, to do your job. Stand up for Canada, stand up for safety, stand up for victims, and put violent criminals where they belong, back in jail. Thank you, Mr. Speaker.
Before we go to questions and comments, just a reminder that we address comments through the chair and not directly to members on either side. Questions and comments, the Honourable Secretary of State, Combating Crime.
Mr. Speaker, thank you for the opportunity. I don't disagree with a lot of what the member says, minus a lot of exaggeration and some oversimplification at times. We are bringing forward legislation that is going to reform the bail process. We have also brought forward other smaller bills wherein a lot of the work was already complete. Our Stronger Borders Act, C2, was the second legislation that we brought into the House, and C9, hate crime, is what we have before us. In a few weeks, we'll have the bail reform as well. So we're hard at work on this. I'd like to know from the member whether he's going to support C2, because what I've heard from a lot of the Conservatives is that they're in opposition to what law enforcement has asked for.
We're from Brantford, Brant South, Six Nations.
Perhaps my friend didn't hear me as clearly as I wanted her to hear me. Law enforcement has been pleading with this government for the last 4 years. They've had regular meetings here in Ottawa and in many parts across this country. They came here to Ottawa for a one-day summit producing Bill C-48, which added reverse onus provisions to a number of firearm offenses, which did not move the needle one iota on community safety. So they're asking her to do her job. We can't wait. The Justice Minister has been promising reform now for the last 6 months. Get on board with the Jail Not Bail Act and protect Canadians.
Question commentaire, l'honorable Drummond.
The honourable member for Drummond. Mr. Speaker, Voltaire said that it's better to save someone who's guilty than to condemn someone who's innocent. This is a principle in all democracies and evolved societies in the world. Mr. Speaker, we should not keep the accused in prison or behind bars rather than freeing them on presumption of innocence. That is against all of the democratic principles we defend. Now, there are countries who do that, China, North Korea, Iran, to name a few. But in Canada, that's not in our values. Mr. Speaker, does my colleague still believe in democracy and the fundamental values we uphold in Quebec and in Canada?
I absolutely believe in democracy. I absolutely believe in the Canadian Charter of Rights and Freedoms. And in that charter, you have two fundamental rights that apply to bail matters. This is bail. This is not sentencing. The right to be presumed innocent until proven otherwise, and the right to reasonable bail. But reasonable bail does not mean absolute bail. And that is the consequence, literally, of Bill C-75. The purpose behind a bail hearing is not to determine guilt or innocence, but in its assessment of risk. And when you're dealing with violent repeat offenders, the easy solution is community outweighs the freedom of the accused.
Questions and comments. I don't member for Prince George, Peace River, Northern Rockies.
Thank you, Mr. Speaker. From Vancouver Sun, February 25th, 2025. Just weeks after former Abbotsford gangster Jared Bacon was arrested in a shooting in Fort Nelson, BC, charges against him were dropped. Witnesses simply just don't feel safe. Ben Wall from Fort Nelson had 9 pieces of equipment destroyed. His shop was burned to the ground. Organized crime has set up shop in Fort Nelson, and again, people in Fort Nelson don't feel safe. Will this bill, the member made a great speech, will this bill make people feel safe in Fort Nelson once again? Thank you.
Member for Brantford, Brant South, Six Nations.
To my friend's question, thank you very much for that question. It was fantastic. Absolutely. This bill will see immediate changes to the safety quotient across this country. There will be a rebalancing of our criminal justice system where the rights of the accused are balanced with community safety and victim safety, and those repeat violent offenders will find it exceedingly difficult, not impossible, but more exceedingly difficult to obtain bail.
Questions or comments? The honourable member for Courtney Alberni, a brief question.
Mr. Speaker, we all want to end the cycle of crime, and I'll give an example to my colleague. In my riding, there was an application for a rapid housing initiative, and the housing was going to create housing for the most vulnerable and people that were also released. This application had a support letter from the Nanaimo Parole Office, from Correction Service of Canada, highlighting they didn't have any beds for clients that they were releasing that had been serving 2 years plus a day. Does my colleague agree that without housing, this application was denied by the Liberals? Denied by the Liberals. Not a single bed, Mr. Speaker.
I have to give a brief time for a brief response. The honourable member for Brantford, Brant South, Six Nations, a very, very brief response.
I'm not sure what the question was, Mr. Speaker.
Resuming debate, please.
I'll talk to my friend after.